I'm Sam Kimball. Today we're going to talk about attendance management. To include or not to include HR protected absences and attendance. Most frontline supervision and managers will agree that when attendance becomes a problem, attendance management can introduce a frustrating and uncomfortable part of the job. Managing attendance in reality is akin to the age-old tip of the iceberg analogy. In the first instance, there is a necessary and human need to be empathetic, supportive, and hands-off, particularly as absences represent a very core intersection between work and the private life of teammates. Many managers are properly reluctant to rush into this space and generally do not do so unless there is a legitimate business need. Paradoxically, an institution gathering more aggregate information can in fact lead to less intrusiveness. Metrics are required to support a more hands-off approach where afforded that luxury, and to focus and intervene where focus and intervention is required. For the same reasons that exist for managers and supervision, attendance management is often one of the more uncomfortable spaces for employees and union representatives to occupy. When the parties dig into their advocacy roles, too much focus and debate can be directed towards differing perspectives as to what can be done or shared versus what must be done. And this disproportionate focus on the part of advocates is often to the detriment of the very employees and the employers they are representing. A recent case confirms that data collection and inclusion of culpable, non-culpable, and even human rights protected grounds related absences can be used as part of an overall attendance management plan, so long as the collection is delinked from predetermined consequences. Modern attendance management requires multiple management response streams in place to address culpable absences, which ought to be addressed through a disciplinary process. Two non-culpable but non-human rights protected issues should be managed through attendance management. And three, human rights protected issues necessarily needs to be managed through an accommodation management response stream. And I would argue that there are multiple combinations and or hybrid approaches to the foregoing that in many cases need to be carefully implemented. Those who've administered a number of these files in the past know that individuals and their behavior do not necessarily fit the three categories above. Be sure to document, show your work, and be thoughtful and explicit in your approach, particularly if applying a combination or hybrid of the three above noted streams. The case Canada Attorney General versus Bodnar reviewed a grievance pertaining to an attendance management policy that counted non-culpable and human rights protected absences for both attendance rate averaging and flagging purposes in order to activate an appropriate management response stream. The attendance management policy in brief. The policy required supervisors to monitor patterns of attendance that may arise under their purview, such as employees missing patterns of particular days, i.e. on Fridays, Mondays, or the day after payday, or exceeding the rolling 12-month average of shifts missed among their peer group. The attendance management program was designed and intended to be non-disciplinary. If it was determined the absences were culpable, that individual would be removed from the attendance management stream and would be managed pursuant to the normal disciplinary process. If the absences were the result of situations related to human rights protected categories, i.e. disability and or family status, those files were removed from the attendance management program and were addressed through a managed accommodation process. Now the lower board decision, Federal Public Sector Labor Relations and Employment Board, found that the employer policy was discriminatory. This is because it included, in their words, statistics and trigger thresholds for absences related to human rights status protected grounds, predominantly physical and mental ability and family status, for the purpose of flagging individuals for the potential putting them into a formalized attendance case management. On appeal, the standard of review of correctness was applied in respect to the prima facie case of discrimination and the effect of amalgamating protected and non-protected leave entitlement obligations, and a standard of in a strong statement and within the context of the reasonableness test, deference afforded to expert tribunals, the court found that the board failed to establish proof of adverse impact by a claimant and unreasonably found that the respondents had made out a case of prima facie discrimination in the absence of any proof of adversity. Indeed, it is difficult to imagine how an attendance management plan could ever function if an employer was required to subtract all absences due to disability from the group average, as the reasons for an absence aren't always immediately apparent, and employees' medical conditions may well evolve or worsen from a transitory illness into a disability, and thus it is difficult to conceive how a bright line could be drawn in a timely way between absences due to a disability and those due to other reasons for the purpose of calculating an average absence rate. Likewise, nothing adverse flowed under the policy from including absences due to disability or for family-related leave in the total number of days an employee was absent for the purpose of simply determining if the employee exceeded the relevant peer group threshold. There is nothing untoward in tasking supervisors with ensuring the legitimacy of employee absences. The court found that not only is it not contrary to human rights to gather the statistics on all absences, it is in fact necessary in order to have a functioning attendance management plan, and the court further confirms the ability for supervision and managers to verify the legitimacy of an employee absence through the normal course of managing their team. With this understanding, we can debate less on what can be done in terms of testing absence legitimacy and gathering metrics, and focus instead on what needs to be done in terms of managing attendance within the appropriate management response stream. Where the rubber hits the road is in respect to having structured multiple response streams tailored to address culpable, non-culpable, and human rights protected absences, all administered with prudence in a dignified manner on a case-by-case basis. Thank you and have a good day.